All right, we are live, Abhishek. You can start.
Okay, thank you so much. Good evening to one and all present here. We at Nyaya Shastram provides and promote the e-learning platform for the law students and the legal fraternity. We organize different types of competitions and webinars and give a platform to the legal fraternity to express their thought in the form of article that we publish on our blog. The workshop on the art of mooting shall entail a brief discussion on the skill of mooting and the interests involved that include memorial drafting, oral pleading, and court etiquettes that form an integral part of the parameters set in any moot court competitions. Talking about Sir, Mr. Sonak Rajguru is an attorney with the regulatory litigation team of J. Sagar Associates, New Delhi. He is a Bar Council of India Trust Scholar for having the fetched the Best Advocate Award male at the prestigious 33rd BCI Moot 2017. Talking about his moot court achievements by his team, including winning the 33rd Bar Council of India Moot, 3rd IIT KGPS RGSO IPL Moot, Ranka Moot UFYCL Jaipur, and the All India Law School Meet SOA University's Moot 4th Best Written Submissions Memorial, three semi-finalist tags, reaching quarters in Stanton twice, and few other achievements. He has fetched the Best Speaker Advocate Awards in 5 mooting tournaments. We are grateful to have you with us today for the session, sir. Thank you so much.
Thank you so much, Abhishek, for having me here and also giving me a platform to share some sort of insights on voting with all the students, as well as who are watching this or will be watching this later, this being recorded. So, to start with, I think, I just wanted a kind of a housekeeping aspect to be made clear from your end. Will this be a purely Q&A session kind of a program, or are we going to like, or would you want me to deliver a lecture kind of a thing, and then we can have the question and answers towards the end? Because I would like
Yes,
if
sir.
the participants would like to interject me in between, and then ask any questions for that matter. Because the purpose of any workshop will be to, clear any such doubts that the students might have, so far as moving is.
Yes, sir. So we will have a lecture first, then we will have a question answer session
Okay, sure.
afterwards.
Perfect. So basically, what I'll do today is I'll divide this session into various parts, and I'm really sorry for a short time frame because I had to cut it down to an hour. And we'll be here, and in next 1 hour, I'll be covering few aspects such as how exactly a team should be formed, what particular moot should be chosen, what are the key determining factors for choosing the correct moot, because I think it's there are a lot of myths about choosing a team, choosing a moot. So we need to bust all those myths. Then I'll be slowly covering the aspect with respect to the moot court propositions and how one should prepare prior to release of the propositions, and what should be the ideal steps followed once the proposition is released, how to interpret the facts, how exactly one should deduce the issues from the facts. Post that, how exactly one should frame the questions of facts and questions of law, based on which you will start researching, and what should be the methodologies for research, followed by how exactly you should go ahead with your drafting, written submissions, memorials, etc. We'll cover all of that. And finally, we'll conclude a bit on oral submissions. I understand 1 hour will be quite short a time for covering all of this, but what I'll try my best is I'll touch base on each of these, at least the most basic elements of each of these aspects, so that we cover mooting as a holistic thing in an hour or so, and then I will leave the floor for various questions. And I would love to take all the questions coming my way, and I'll try my best to answer those questions. So to start with, I think the first and foremost thing, no matter in which year you are in, whether you are a first year student or whether you are even a fourth year or final year student, what you need to be very, very careful about is choosing the right team. Now, why that's important is, mooting is all about preparing yourselves for over a period of time. It may be 2, 3 months, maybe 1 month, or maybe sometimes 8, 9 months, depending on which moot you're participating in, right? And therefore, all you need to have is a good team which will struggle together, which will prepare together, and which will achieve together. And why I'm emphasizing on the word team a lot, because mooting is all about teamwork. You may be a good speaker, but until unless you are completely merging well with your team, you are having a good compatibility rate with your team members, it's very, very difficult to sustain the preparatory stage for any moot court competition. Therefore, it's very important that you choose your teammates and make sure you are compatible with each other. You are absolutely in tandem with, the mindset may change, the timings of preparation may vary, but what is important is all of you should be having a common intention and goal, that is to win the moot court, right? And for that, I think what's the primary thing you need to ensure is, mooting need not be, or rather, teams should not be formed merely by the fact that he or she is your really close friend, or someone whom you know well. But what should be the key consideration is whether someone possesses the requisite amount of skill which is required to perform well in a moot. Now, what do I mean by these skills, and how do you determine that someone has that skill? See, for a moot, there are two essential speakers and one researcher in a general moot. The researchers may vary, the number of researchers may increase in some moots. What is very important for a speaker and which you should look for in a team is analytical and rational analysis based skills. Now, why that's important is being a speaker, you can't just be technical in your approach. You can't just go and cite something on in the air without any analysis, without any rational being provided to support your contentions. Every submission in law requires further substantiation, and that substantiation may be in the form of relying on some authorities of law, maybe analyzing the facts and applying the facts to your case, and various similar analytical approach is required to be followed. And therefore, as I always believe that you may not be very fluent in English or the language with which you are speaking, but if you have reason, if you have logic, the argumentation will automatically follow. And therefore, you should look for those kind of people for as speakers in your team who have these kind of skills, who can explain things in a much better way, who can demonstrate something by way of examples, by way of reasoning, by way of logic, and will substantiate everything that they want to argue, or even make a statement. I think these are very, very essential skills that you need to look for in a speaker. And hence, the moment you feel that someone is capable of doing that, I think that is where the preparation starts. And you need to choose them as your teammates, or you may have to request them for being your teammate of yours. If you think that you are a capable speaker enough, make sure you either build yourself on these lines of skills, or if at all you already have them skills, then please do your best to hone your skills more and more so that you become an efficient speaker. So far as the researcher is concerned, I always feel that someone who is very, very efficient with the work, because see, research is something like someone can read a judgment in 2 hours, someone can read a judgment in half an hour, depends on how much of judgment someone reads on a regular basis, because that is also a key tendency towards efficient research versus simple research. So always make sure that you have a team which is more efficient, which is compatible with each other, and which fits into their respective roles as a speaker and researcher very well. And one advice, which is a very general advice, I don't know whether all of you follow it or not. Whenever you choose your team, make sure you determine your speakers and researchers right at that stage. The problem is if you leave it open that, oh, we'll decide it at the fag end before going for the moot. A problem is everyone wants to be a speaker, and that is definitely a healthy practice. It increases the competition within the team, but at the end I have seen several instances where someone who ultimately has to have become the researcher has not given his or her best performance, maybe because he or she wanted to be a speaker, and somewhere or the other that lag happens towards that phase when you are not given the role that you wanted to be. However, honestly, I want to make it very clear that a speaker and a researcher are given the same kind of treatment anywhere. So far as the mindset of the judges is concerned, they see everyone equally. Because as I mentioned right at the outset, it's completely a teamwork, and it's all three who have to equally work together in order to prepare that team and build that team so that it's they have a common aim, and also make the name of the college proud by winning a moot for the college. So that's about you choosing a good team. And how do you know that? Maybe in the first year, I'm sure you are not aware of your classmates, batchmates, or seniors whom you should be ideally teaming up with. I think the best practice is, analyze from very simple things like on someone answers a question of a professor in a class, see whether they have some sort of reasoning or logical approach while answering. I think that is one way in which you can figure out whether someone on will have those requisite skills for becoming a speaker. Apart from that, participate in your intra college rounds. Then that has a lot of researcher tests, that has a lot of speaker oral round sessions. I think that also gives you a good amount of opportunity of knowing each other well, and based on that you can always prepare your team for the national rounds later or international rounds later, right? So that's all about choosing the team. Now that's always step one. Now once the team is ready, the second step is choose the right mood. And why this is very very important is I've seen students being fancying that, oh, I want to go to this and this XYZ college because this and this has a great name. But what I always believed while mooting was, I always emphasized on what exact area of law does the college conduct a moot court on, and secondly, what is the exact nature of the proposition. For example, if I wanted to do a constitutional law moot, I did not care what's the name of the college, how prestigious the college is, or how renowned the college is. What mattered to me was whether the proposition is such that if I have to research, if I have to give 2 months of my time, whether that will be fruitful enough in terms of my own learning and understanding the law, more than getting a good certificate even if I win them. And that was my priority. And I would suggest that that should be the priority for almost everyone, because it doesn't matter which college organizes a moot. What matters is what is your learning out of that moot, whether you are actually going for the sake of going, or whether you're actually learning the law, interpreting the law, knowing the law the best before you actually come out either as a winner or as a participant, or not making it to oral rounds. All of that is immaterial. What matters is the journey during which you will prepare, the journey during which you will learn and interpret the law. And I think that's the very very essence of the practice of mooting, and that is what everyone intends while conducting a moot court competition. Therefore be very very specific while choosing a moot. Do not just choose the moot by some other sorts of considerations, but the practical reality is choose the mood. The area of law should suit you the best. The kind of approach you want to follow in terms of your career also, that should align while you choose a mood. For example, if you are a corporate law enthusiast and if you turn up doing, say, a criminal law mood, the recruiter 5 years down the line will ask you, why did you do a criminal law mood if you wanted to join our firm, or if you wanted to enter into the corporate law field? The answer, you'll be left with no answers, right? You can't say that, oh, back then I was interested, now I'm interested in corporate law. That's not a good tendency so far as the recruiter is concerned, because the fluctuating mind gets exposed at that stage before a recruiter. So you need to understand that mooting does not end with the activity of mooting itself. It leaves a footprint in your CV, and that CV gets reflected going forward at various stages. Therefore, you need to be very very careful in all your considerations while mooting. And but having said that, I do not try to develop a culture of restricting yourself to particular fields of law. All I wanted to say that if at all you're doing hardly 1 or 2 moots in your whole 5 years, right, then I will suggest that you choose the moot based on the subject you are interested in. But if you want to do more and more moots, if your college is giving that opportunity, if you are willing to do more moots because the activity interests you, then please start with the basic subjects in which you are interested in, and then slowly please start going out of your comfort zone. And that is how you will expose yourself to different laws, and it will ultimately give you that sense of comfort and confidence in dealing with a law. And at various stages, I'll give you my personal experience in this. So what used to happen was, I was getting a lot of opportunity for mooting back in my college. For example, when I started mooting exactly 5 years from today. And yes, it is 5 years from today. So 22nd of November, I started mooting in my second year. And what happened was I could do about 4 moots in the next 6 months. And based on that, what then happened was I was getting a lot of opportunities for mooting. So I thought of, instead of restricting myself to very general laws like criminal constitution laws and various other laws, I started going beyond my comfort zone. And that is where I thought of doing the IIT Kharagpur Moot, which was on international patents and various transfer pricing issues of taxation. And I felt that, that was one of the best experiences I had. Plus it was one of my best performances, because I had to give everything I had in order to prepare for that move, because I had to be extra sure. I did not know the law. Indian jurisprudence was very, very less in that entire matter. Therefore, if you do that sort of a thing, and if you also have a sense of doing your best for that, I'm sure you will put all your efforts into it, and that will ultimately reflect. And we ultimately went ahead and won the moot. So you never know what sort of area of practice will be involved so far as mooting is concerned. Therefore, just as a very general thing, if I have to sum this up in terms of which moot to go for, first consideration is always the area of law. Second consideration is the particular subject, in the form of what are the questions involved, whether you are involved. For example, constitution is quite vast, right? You may be deeply inclined towards fundamental rights based issues, but you may struggle with money bill related issues. So you need to be very, very careful that although it's a broader constitution law moot, whether the specific areas or specific subject matter or issues covered in that moot will be of any help to you, and accordingly you should plan for your mood. So I don't want to indulge more into these basic elements, but why I wanted that to be emphasized right at the outset is, people often ignore these two things of forming a good team and choosing the right mood, and that is always detrimental for your overall performance in the moods. And therefore you please start giving these two things importance, and that is how you will actually develop your mooting skills in such a way that it will ultimately reflect in your performances. So these are two very, very basic aspects that you should keep in mind. Now let's come and talk more about the real mooting thing in the form of proposition and other aspects. So once the team is ready, once the moot is chosen, the next thing is you wait for the proposition to release. Now what you should do before proposition is released is learn the very basics of the law. Most of the competitions do clearly indicate what exact subject area they're going to come up with in the form of their own moot court competition. For example, they declare that, okay, this year we are going to organize a competition on artificial intelligence. Then what you have to do is you need to read the law regarding that subject. You need to read the statute. You need to read the statement of objects in reasoning, which is basically something that precedes the statute. You need to read the preamble well. You need to read the statute line by line, followed by the landmark judgments, and keep your basic knowledge or domain knowledge ready in the form of interpreting the facts well once it is released. And you will always see that the moment you actually join or rather get into a moot and then get the proposition, you will be able to comprehend the facts in a much, much better way with some sort of domain knowledge versus when you do not read any preliminary aspects and then read the proposition for the first time. You may find yourself completely clueless, and you might not even relate yourself to the facts. So I think it's very, very important that you need to have some sort of basic knowledge about a subject before you actually start reading and comprehending the facts. The also another benefit of doing that is you'll be able to understand, okay, this fact is maybe for this purpose, or this fact maybe is related to this issue. So you will start bifurcating and churning of the facts in a much easier way if you have some sort of domain knowledge prior. So that's very important. The next thing that you need to do is when the proposition is released. And once that is released, please prepare a table. Okay, on the left, you can have the disputed facts in the case, and on the right, you can have the undisputed facts of the case. Now, what happens with this analysis is disputed facts, I believe, are the foundation stone for the issues to be framed, because no one is going to contest an undisputed fact. It's only the disputed facts which will be contested in the court of law, and the disputed facts will therefore lead to the issues, maybe a question of fact, maybe a question of law, and finally the arguments will revolve around the disputed facts. So you keep all disputed facts on the left side of the table, and on the right side, you keep the undisputed facts. Now, what is the relevance of undisputed facts? They help you connect the dots while making arguments, so far as the undisputed facts, so far as the disputed facts are concerned. Now, I'll give you a short example to explain this situation. Now, consider there is a husband, there is a wife, and there is a watchman. Now, the watchman has seen that the husband was last seen with the wife, and the next morning, the watchman sees that the wife is lying in a pool of blood, is dead in her own bedroom, and the questions that come out from this, or rather facts which come out from here, first of all, what is an undisputed fact here is that there was a watchman in the house. Second undisputed fact is that they were husband and wife. And third undisputed fact is the watchman has seen the husband last night, until unless this fact is obviously discredited by way of substantial evidence. Now, what is a disputed fact in this small narrative of facts is whether the husband has killed the wife, whether the watchman has killed the wife, or is there a possibility of a third person entering the house and having killed the wife? So, what I gave you is one single sentence of fact, and I divided that into a lot of disputed and undisputed facts. And you will realize that questions of law, such as plea of alibi, if the husband has to say that no, I was never present in that house that night, if for example the other questions of law or rather fact in the form of if someone else could have entered, what is a murder weapon, who could have killed, where are the fingerprints, etc., all of that will revolve around the disputed facts of the case. But no one is going to question about the relationship between the man and the woman, because it's already settled and undisputed that they were a married couple. And therefore, all I'm trying to say is, if you have to really figure out what are your issues, I always believe that you have to churn out your disputed facts from the undisputed facts. You prepare kind of headers, and under those headers, you need to fit in your disputed facts into each header. And then your each header will be converted into form of a question, which will become your issue, and based on which you have to proceed with your research. And where I'll give you one example now where you can utilize the undisputed facts of the case for your arguments is I'll give you a real instance where I had done that in one of the moots, where epinephrine, which is a chemical, was used as a poison to kill an individual. And in that particular instance, the argument that I had taken through substantial scientific evidence that 50 milliliter of epinephrine is not enough. 250 milliliter is the minimum requirement that you need to have in order to kill an individual. And based on that argument, and so well supported through scientific evidence and documents, I could prove the fact that the prosecution relied on an undisputed fact that the quantity was only 50 milliliter. And I used that undisputed fact to turn the case in my favor, where I could easily argue that no, if at all you consider 50 milliliter, that's not enough. What is enough is, or rather the minimum requirement being 250 milliliter, the prosecution's case cannot be relied on so far as the guilt of the accused is concerned. Based on that, I could succeed in my case. So all that I'm trying to say is undisputed facts such as figures, data, measurement are very, very important. Do not ignore them. Even a population figure may sometimes be important of a particular country, because that may determine the per income, per person income, or per person, various other forms of data. If at all some economic analysis is being done for particular issues, please do not ignore these small aspects. And if they are in the facts, they are there for some reason. Okay, make sure that you need to use each and every corner of the fact sheet very, very well while interpreting the facts and analyzing the law. So that is very, very important so far as the facts are concerned. Now, as I mentioned, once the facts are ready, you can easily divide the disputed facts into various headers or chapters, and you convert them into questions. That is how you get your questions of law and questions of facts. And therefore, we already covered your issues segment. Now, once the issues are ready, once you have your basic set of facts ready, the next thing that you obviously need to do is research. Now, I would suggest a three-stage research, or a three-based methodology-based research. The first is, I always used to follow an old school methodology. So the first is general, commentaries, reading the text of the law first, followed by the commentary, followed by the landmark judgments, all in step one. Now, what I mean here is you need to completely understand the language of the law, because statutory interpretation is very clear that the first means of interpretation of any law is read by the statute itself, read the way the law is written, and if it's unambiguous, that is the interpretation that has to be followed. And therefore read the law well, read the commas, read the ands, read the disjunctions, or everything as such, read it well. Read the preamble in order to connect with the arguments well. Read the headings of the provisions and connect it to the substantive portion of that particular provision, and whether they are making interrelated relation based sense or not. So all of that analysis has to be first carried out. The second thing is read a commentary. Now, why a commentary is important is, imagine a law that you're reading was enacted in 1960. A commentary was maybe published in, say, 2014. Now, at least 1960 to 2014, the entire journey of that particular law, the interpretations, the various judicial pronouncements, the difference in opinions of judges through the years, through changing times, through changes in societal values, etc., is clearly analyzed in a commentary, right? And you will get a thorough picture of how the law has developed, what is the position of law as on date, and how exactly it has been interpreted through the times, since its enactment. What it gives you is a clarity of thought of why the law was in place, how the law has been interpreted, what are the lacuna in the interpretation of law, what is the lacuna in the provision itself, and various similar aspects through which you will have to build your arguments. And why that's also important is, maybe, if you just go for an online research, maybe you be you sometimes be happy with getting one single judgment and leave it there, ultimately to realize that that was an overruled judgment, which you have ignored looking at. So I think a commentary gives you that whole picture and clarity of thought, and that's very, very important. The second thing, rather the second step, is what I believe is good and efficient online research. Now, for this, I know, I'm quoting this, although it's in public domain. Please do not rely on something like India Qanun. Do not rely on something which are easily accessible on the web. The problem with them is they're easily editable, and the Supreme Court as well as various high courts have obviously and very often condemned these particular websites. Rely on proper websites. You can rely on almost all subscription based websites such as SCC Online, Manupatra, Hen Online, JSTOR, Westlaw, and various others which are ideally available. I hope all of your colleges will be making these things accessible to you. So you rely on all of that, and fill that gap of 2014 to 2020, that is the date of your publishing of that commentary that you read, and what is the law as on date, because it's very, very important that you have at least knowledge of one landmark judgment and two recent judgments for any given issue. I mean argument, not the main issue. So every argument that you have to make, you should have at least three judgments to back it up. I used to have 5-6 judgments, and that's only for a safe side, because you sometimes get judges who will be like, no, consul, we are not very happy with the judgment. If you give them one more judgment of the very same issue saying the very same thing, they will still be like, no, this may have been applicable with the facts of that case. Then you give another judgment reiterating the very same para. Then that just gets further strengthened and also shows that you have done some sufficient research before concluding your research on a particular aspect. So I think holistically speaking, these are the first two steps of research. That is the basic research, commentary-based research, learning the landmark judgments, and second step is online research and keeping yourself with the pace of the present day law, or rather the extant law, right? So that is what you need to do. The third step and the most crucial step, and I believe that most of you ignore this aspect, is as lawyers and even as therefore more participants, we need to know something beyond the law also. As I mentioned in my example, when I talked about that 50 versus 250 milliliter epinephrine, it would not have been possible to argue that had I not read up some sort of scientific evidence to that extent, which has nothing to do with the law. And therefore, sometimes propositions demand knowledge beyond law, and it's always beneficial. And I believe that's the X factor in any moot. If you have knowledge beyond the law, if you have some sort of technical knowledge on some portion, provided the proposition deals with such aspects. Another example will be environmental laws, where knowledge about climatic changes and conditions is sine qua non for if you have to argue a moot in environmental laws. You need to sometimes know the ocean temperature. You need to sometimes know the dynamics of marine life. Sometimes you have to analyze why a virus has spread and why exactly the virology could not have been ascertained, and what sort of precautionary measures should have been taken in such a situation. And therefore you need to be very, very careful while knowing something beyond the law. And I always have believed that if I have something in my armory, the best possible weapon was knowing something beyond the law, because that is what made me or my team different from others. And we were winning moots and various rounds by rounds by having that particular amount of extra research with us, which was nothing to do with the law. Therefore, I would definitely suggest that all of you should, inculcate that tendency of knowing beyond the law, so far as the proposition demands, obviously, nothing beyond that. So I think that's a very, very important approach. Okay. So that's all about your research. Now, what matters is the memorial. Now, written submissions are very, very essential so far as you need to have certain basic elements to it. I don't think 1 hour will be sufficient enough in order to cover a lot in memorials, but what I'll definitely try my best to do is just give you like 3 4 basic information regarding a good memorial, and based on that I'll proceed. So first of all, you need to be very sure about your footnoting. Now, footnoting is where you need to cite authentic sources. You can't give or mislead anything in your footnotes. Your citations have to be perfect. You should have followed the proper citation formats. And with that citation formats, you should have adhered to the exact requirements of a particular edition of a citation rule. Now, ideally, your rule book of memorials for memorials, as in, will clearly indicate what is the citation that you need to follow. So make sure you follow that citation, because ideally I've seen if you are not following a citation format, then that often has resulted in a lot of marks being deducted. The second thing that you need to be very, very careful about is your prayer. Now, in your prayer, you need to be very specific in your approach, and you need to have a very clear prayer. You can't just repeat your issues in either in affirmative or in negative, or copy pasting them in your prayer and then saying that, oh, I want this, and don't make it look affirmative, negative sort of a thing. Clearly put a prayer which you want from the court, and make sure the court can even give you that relief. Because often I've seen, you know, that sometimes people have claimed prayers and have often neglected the fact that the court is not even empowered to give that prayer, or to grant the prayer. And that's very unfortunate so far as the research portion is concerned, because you have to be very, very careful with your jurisdiction and also the powers of the court to grant you a relief which you are exactly asking, or what your client wants from the court. So therefore, choose the forum well, and accordingly your prayer will automatically fall in place. Now, the next important thing about memorials is where you need to have like really good, questions framed. Issues should be short and crisp, and at the same time, what you need to be very careful about is your sentence framing, and you have to follow IRAC everywhere. Now, what I mean by IRAC, and I'll go a bit slow here. I stands for issue, R stands for rule, A stands for analysis, and C stands for conclusion. And why this is important is your every para, every issue, every sub-issue should independently follow IRAC, and that way the whole memorial will follow the methodology of IRAC. Basically, you need to pull out the issue first. You need to cite a rule or a case law or a law per se, and then you have to make an analysis, apply the facts of your case to that case, and make a complete analogy of the same. and conclude by a sentence or two saying that in view of the above, this is the position that you want to argue. And that is how you need to follow for every para, every issue, every sub issue, right? So that's the third important element. And the fourth important element, or rather an advice for all of you, is have as many as issues, sub issues, sub issues, and sub issues, going forward. And that's very, very important because that just breaks your chain of thought into multiple segments and also gives the clarity of thought to the judges and also to the memorial evaluator that yes, these are the primary arguments that you have actually thought of, and then your para will basically be an explanation of that argument. So give as many as sub issues as you can, give further sub issues. Sub issues and issues are basically like the subset arguments of a broader issue. Like if you are claiming maintainability, then your first sub issue is why a petition is maintainable under 32. The first sub issue under that will be that there is a violation of fundamental right. The second sub issue is that there is the violation of fundamental right has been carried out by the state concerned, and the third is the court can give relief in the form of any sort of exact mandamus or any other writ that you're seeking. Now, sub issues and further sub issues of this would be under the violation of fundamental right. You can always prepare your sub issues saying which all fundamental rights independently have been violated, and then prepare sub issues in order to justify those each individual violation. And that is how you will have your general flow of thought and various issues, sub issues, and sub issues develop. It's like that big box having multiple boxes inside, and you need to couple it up. Your ultimate memorial is that biggest box, and your issues and sub issues are the smaller box which are kept inside that bigger box. And that is how your memorial should ideally be placed like, right? Lastly, I'll touch base on the oral advocacy aspect, and that's very, very important, and that's the most important stage in any moot court competition. Now, I have always seen students, starting for their oral advocacy and speech, etc., at the very fag end of a competition. It's not really good to do that. Uh, Always, start from the very basics. For example, if your issue one is ready, if you have already drafted one issue, the first speaker or the second speaker should start, speaking and start making a habit of continuous speaking before you actually go for the moot. And that way you can easily get a hang over your speech. You will easily get a hang over the law, and you will further keep developing your speech by adding more and more research to it. And do not think that memorials once submitted means end of research. No, memorial once submitted means do more and more research to further substantiate your arguments. That's very, very important. And what I have always believed is, for example, if you have cited 3 case laws in a memorandum on a particular argument, have 2 more prepared during this, speech stage, and rely on that during your oral submissions. The benefit of that is you're not saying something out of your memorial because the concept of law is already there. All you are doing is you're relying on a new judgment which is not quoted in the memorials, and that leaves a kind of an impression on the other side that they won't be ready on spot to rebut you on that case law. And that's a very, very important approach that you can follow. The second approach is always have a good speech prepared. And good speech, I mean, you need to have a separate speech for your final rounds, a separate for semifinals, separate for quarters, and separate for prelims. The reason why I'm saying this is each of these rounds have different time limits, and you have to adhere to the time limits. At the same time, answer the queries of the bench. And sometimes if you get a bench which grills a lot, you will hardly be left with any time for your speech and completion of arguments. So in that stage, my advice would be to focus only on answering the questions of the bench, because the moment you do that, you'll be considered as if you are, well prepared. And I think that serves the purpose. You need not really complete all your arguments. Focus on answering the questions of the judges, and that's the most important aspect of oral advocacy. Do not, or rather never ever say that my co-counsel is going to deal with that answer, or never ever say that I'll be dealing with this answer while I deal with my issue number 3 or 4. If a question is asked right now, answer it right now. That should be the approach, right? And because see, As judges, sometimes we know that you would have well prepared it with your speech. Sometimes, especially knockout rounds, we know that you would have crossed your prelims. That means some sort of fundamental and basic research and preparation has been done. That's the reason why you are there in the knockout round. There, what we test is your question of law and the knowledge of law, and that's very, very important. So just focus on answering the questions during the rounds, and that's very important. Second, whenever you quote a case law, make sure you know the facts of the case start to end. You can't be just citing a case law without knowing the facts. Personally saying, I've just over 10, 15 moots in the last 2, 3 months, and much more beyond that. And I have never ever allowed a speaker to quote a judgment if he is not knowing the facts of that case. No matter, that judgment may be the apt judgment, but if he or she is not knowing the facts of the case, the judges will not allow to even quote that judgment. So please be very, very careful whenever you rely judgment. Make sure you know the facts of that judgment. Secondly, know the bench strength. Know how many judges have rendered an opinion, and that's very important because you can't cite a two-judge bench based decision, uh, where the other side might have quoted a constitution bench decision. So you need to be very careful about these aspects also. One last important advice from my end would be always prepare a compendium. And what is a compendium is basically a list of documents which are nothing but the authorities of law that you want to cite, other documents that you want to cite, that should be properly compiled and submitted to the organizers well in advance so that it can go to the judges. Now, why that's important is when you prepare a speech, you can write just 1, 2, 3, 4, 5 against all the authorities, and have the compendium numbered in the same sequence of 1, 2, 3, 4, 5 by way of flags. And I'm talking of this when physical moots are back in the foray. Okay, so what you can do by that is you will have a flag which will clearly say 1, 2, 3. All you will do, you will have your speech with you, and you can easily say that your lordships may kindly refer to flag 3, which contains the judgment of Kesavananda Bharati, and I'm relying on para 45, wherein this was held, and then you go on quoting that para. Try your best not to read anything while even quoting a judgment. That sends the very, very, very best sort of an impression of you as a speaker if you can do that. And that will happen only with consistent practice with your speech, with your research, with your knowledge of memorial specifics and various other things. I used to prepare over 50, 60 times, so far as my speech is concerned, before I used to go for any moot. And my days of preparations included like about 14, 15 hours of daily preparations, so far as moots were concerned. So I think I'm not sure whether your college hours will permit you to give that much amount of time towards mooting, but make sure whatever time you have, you do that efficiently and effectively, and based on that, I'm sure you will do your best. I leave the floor now for any questions for the next 10 minutes, and I think then we can in the session.
I would like to ask participants if they have any questions to ask, they can write it in the chat box. Sir, we have a questions from Aniket Datta. He asks, Sir, can Manupatra citations for case law be considered as authentic?
Yeah, as in the Manupatra quotations are fine, but so far as the citation, the Manu citation is concerned, is ideally not that authentic. It's better if you can either go for SSC or AIR citations, which are often on the top left in the Manupatra version of a judgment. Don't cite a Manu citation, but do cite an AIR or SSC or SCR, which is Supreme Court reports, which is again mentioned in the Manupatra version of a judgment itself. So I think that should suffice.
Thank you, sir. Participants, do you have any questions? You may write in the chat box. So there's a question. While doing any moot court, there are certain facts which are undisputed and against us. So how to deal with that?
See, I think whatever facts are against you, you can't obviously do anything with that. But build your legal research in such a way that try your best to come out of that fact in the best possible manner, and that's very, very important. For example, if there is a thing that okay, in this very same example which I mentioned, the husband, etc. The watchman is testifying that, oh, the husband was last seen, and that's a fact which may be running against you. But if you can give a contrary fact, or if you can prove through other documentary evidence that you were not even present in that house, that is how you exactly can come out of that fact. And that is exactly what you need to do so far as mooting is concerned. There are a lot of things which will be some against someone, but if a proposition is tilted a bit towards one party, the judges do know of it, they do note it, and what do they then see is to what extent possible, or what is the best case put by someone who is on the other side, who is on that side where the facts is not tilting much towards them. So it's the effort which is seen in the competition. Do not think that had it been a real situation, you might have lost the case. But if you can give your best possible effort, you can still try to justify your case as the best case forward. Then I think that will be appreciated more than anything else. So I think it's your effort which will be seen in the form of making sense, in the form of sticking to the legal points, and then we know it for a fact that something which is not in your control, being the facts against you, obviously you will not be marked down for that. But what is important is what effort you put in. That's very important.
Sir, I'll read out the next question for you. So Arya asks, Sir, can you throw light on the statement of jurisdiction, as it seems difficult for one to write from the respondent's side?
See, a statement of jurisdiction, if the respondent is disputing, only then please write it clearly stating what should have been the right jurisdiction and why the jurisdiction has wrongly been invoked. But if the respondent is not disputing the jurisdiction in a given set of facts, just say that the petitioner is approached under this and this forum and we submit to the jurisdiction. That's it. And you can end it with that, because unnecessarily you need not write something in the statement of jurisdiction if at all you're not disputing the jurisdiction at all. So that is something you can keep in mind.
Sir, Lolita asks how to manage time as well as complete the entire argument with proper speed and etiquette.
See, the thing is, as I mentioned, do not focus on completing arguments. Focus on answering the questions of the judges, and that's very, very important. Second thing is, if you are running out of time, cut short your arguments and put your best pointers forward, and that would show that what is the best argument you had under a particular issue. You might have 5, 6 arguments under an issue, but what matters is what is that one key thing which would have taken you across the border, and that is that thing you should clearly point out. And say, for example, if any judge mentions you are left with 30 seconds, throw the last 3 most relevant pointers that you think that in this issue our argument is this, in this issue our argument is this, and that is how you need to conclude. And that is exactly how you also make sure that you are remaining calm, you're not letting the judge know that, oh, you were left with 5, 6 arguments. At the same time, you are also completing your argument and not letting an issue uncovered. That's very important.
Thank you, sir. So Maria asks, is it necessary to be well versed of all the cases cited in the memorandum apart from those cited in the speech?
Safe side, yes, for your safe side, because I've seen judges who have asked questions from the footnotes, and it's basically that if you are citing a judgment, you should be aware of the facts of the case, and therefore I would advise to know each and every fact of a judgment that you have quoted in the memorial as well as in your speech. So yeah.
Yeah, so Sir Arya asks, in moot courts, we can only argue on the basis of facts of the case, but at times it is asked by the judge to prove the validity of the fact. So I get stuck there, as it can only be proven through chief and cross examinations, which is not allowed in moot.
See, not really all the times. Obviously, last part I agree. Obviously, you can't have the benefit of witnesses, but mostly I have seen propositions are framed in such a way that there is one fact which is correlated to the other fact, and a combination of all such facts will prove each other's validity. For example, or rather, I would say relevance, if not validity. Okay, so the relevance of the facts can definitely be proven considering the nature of the proposition. And I'm sure in the proposition there was something or the other through which it could have been done. Because if not, then ideally I would say that it would not have been a good proposition, and that's an unfortunate thing, but which is not in our control. But I always have seen mostly that if we ask a question, or if I had to answer a question back then as a motor, I always had something or the other in the fact sheet to substantiate, or if not, I always used some law to substantiate a fact. Sometimes that's possible, and but that completely depends on the nature of the facts.
The next question asks, is it necessary to mention a legal provision verbatim on the memorial and then apply to the given set of facts?
See, absolutely. If you are arguing a case, the basis or the source of law is to be highlighted. And that's the way you need to proceed with your legal submissions. Without that, no submission would be complete in the legal sense. Therefore, why will the court believe you if you are not citing any provision of law? Okay, it's all about making submissions which have authority, or rather backed by the authority of law. And that is the reason why you need to quote everything in a memorial, and also at the same time while speaking. Yeah, and that's what I mentioned about IRAC, and R stands for this, where all sorts of authorities, rules, etc. are to be quoted. So yes, it has to be covered.
So I have a question to that in continuation. So most of the times we have a page limit constraint in terms of arguments at one section. So how many case laws should we ideally rely upon? So
See,
is only one
see, I've
case law?
seen. Yeah, sorry, please go ahead.
No, no, sir. So is if I find a case law which applies completely, the facts and everything, the analysis is exactly what I'm looking for based on my mood proposition. So is it okay to stop my research there, or should I look for more case laws?
See, it's never advisable to stop your research at all, at any stage, even if you have gotten 10 judgments saying the very same thing on the same issue. Continue more and more, because you never know, there might be something in that judgment which will render that judgment inapplicable. Maybe one major fact changing, lose in a way, you lose the binding value of that particular judgment so far as your facts are concerned. Therefore, first advice is, yes, never stop researching, and research it till the time you are actually winning the moot court, and that stage research should complete, right? And sorry, you had one more leg to your question at the outset. You said something more to that.
Yes, sir, to cover the page limit constraint
Correct.
in
Correct.
manual.
To cover the page limit aspect, see, the thing is, I've seen sometimes there are word limits, sometimes there are page limits. And when it's a word limit, sometimes they include footnotes, sometimes they exclude footnotes. When they exclude footnotes, good enough for you. You cite as many as cases that you want. It's not an issue. But when they have a page limit, it's important that maybe instead of citing 10 judgments for very one simple footnote, you may reduce it to 4 or 5. If you're citing 4 or 5, you reduce it to 2 or 3. So that is what you can do. But when you are starting off, start off citing everything. And then once you have the final memorial, like the final first draft, then you start churning out what should be removed. I would always advise, to remove more from the content than the footnotes. Okay, and because I have always seen unnecessary things mentioned in the content, while footnotes are very relevant because you are giving the authorities that you have actually read inside. So my mostly if you see any of my memorials, it will be like more than half a page footnotes, and or maybe 1/4 of the page being the content of that particular of the memorial. So that is how I used to follow in most of my moods. Obviously the later ones, initially even I was going with that flow of having a balanced approach for the content and the footnotes, because I then believe that no, footnotes can actually cover more than what I want. In the form, if I have quoted a case law, I can easily cite it at any stage, and I can develop my arguments based on that, right? And what matters at that stage will be the oral arguments. So that is how you can actually balance your approach in memorials.
So we have reached the time. If you'll permit, we can.
I can take up one or two more queries and then we can conclude on this.
All right, sir. So I'll ask a new question. So could you elaborate anything on court etiquette?
Yes, I think that's. I'm really sorry. I should have covered that in my oral advocacy aspect itself, because that I believe is the most important aspect so far as speaker is concerned. You need to be absolutely humble. You need to be absolutely polite in your approach. I've seen students and participants being aggressive when some sort of questions are being asked to them, and they are if they are not aware of it, there is a change in body language, as if, oh, why are you even asking me these questions? Those kind of body language will not help you when you are participating in a round, and in general when you enter the bar, right? Second thing is, maintain your hand and leg movements really well. They should not be any such hand movements. It's not a parliamentary debate going on where you make those hand and leg movements here and there. Be stand upright in the podium, and obviously all these are applicable when physical moves are back to normalcy. But even in virtual forums, never ever read from your screen, because ideally, if you, especially if you're wearing specs, we get to know. And even if you're not, your eye movement is very clear. If it's going left to right on the screen, we get to know that you are reading from the screen, right? So that is where that forms part of an etiquette itself, because you're not maintaining an eye contact with the judges even virtually, and that's very important. So maintain eye contact, engage the judge well, and that is through your facts, and that is through your memorials, and as well as your compendiums. Keep them engaged, or else they're bound to sleep. And therefore all these things are very, very important. Courtesy, mannerisms, they are all carrying marks. At least I have seen out of 100, 10 marks are for courtesy and mannerisms, etc. So please do follow all of those general techniques, that before entering into a particular issue, before starting your arguments, take the confirmation from the bench, all of that sort. Okay, especially if there is a lady member on the bench, make sure you address them collectively as lordships, if at all it's allowed or agreed by the bench. And while answering back to specifically to a query from the lady judge, do refer back as ladyship, so that you are giving equal respect to everyone and no one is taking any sort of offense so far as the general mannerism tactics are concerned, right? So I think that's very, very important, and all of that should be taken care of in any moot court competition.
Thank you, sir, for conducting this Q&A. I can see a few more questions, but I'd request the participants to go back to the workshop, the presentation, as sir has already dealt with these aspects in detail. It will be available on our YouTube channel. Now, over to you, Abhishek.
Thank you so much, sir, for accepting our invitation. Now I would like to call Jia Jain for vote of thanks. Jia,
Gia, you're not audible. You're muted.
Good evening. Good evening to one and all. I'm Zia Jain, Head Social Media Department, Nyaya Shastram. Uh, I would like to thank, on behalf of the team, my heartfelt gratitude to Sir Mr. Sonak Rajguru for taking out time from his hectic schedule and sharing the experiences of his mooting journey in the law school. I'm sure that each one of us are going to take away the tips and tricks on mooting and will leverage them onto our participation in the upcoming moot court competition. I would further like to thank Mr. Abhishek for making this learning that we have come to the conclusion of this workshop. Thank you.
Yeah, thank you everyone. Thank you so much for having me. I really had a great